Supreme Court reserves judgment in Atiku Labour Party's appeal, dismisses APM's appeal. Victory for Nigeria's UK court halts enforcement of $11 billion P&ID award. And President Bola Ahmed Tinubu announces student loan scheme to begin in January 2024. And outside of Nigeria, Rwanda sends 16 tons of aid to Gaza. The European Union begins steps to sanction Niger junta. I am Benga Aborowa. Stay with us, Politics HQ. We'll be right back. The Supreme Court earlier today reserved judgment on the appeals filed by the presidential candidate of the People's Democratic Party, Atiku Abubakar, and the presidential candidate of the Labour Party, Peter Obi, against the victory of Bola Ahmed Tinubu at the Presidential Tribunal. A seven-man panel led by Justice Inyang Okoro made the decision on Monday as the counsels for the involved parties adopted their briefs of argument and made their final submissions. The counsel of Atiku Abubakar sought the disqualification of Tinubu after filing fresh evidence against the incumbent president. Counsels of the APC, Tinubu, and the Independent National Electoral Commission, INEC, however, asked the Apex Court to dismiss the appeal, claiming that it lacks merit. Now, joining me to discuss this development is Barrister Deji Ajare, a legal practitioner, and Barrister Okoye Obono Obla, former chairman, defunct Special Presidential Investigative Panel. A warm welcome to you, gentlemen, and thanks for joining me on Politics HQ tonight.
Good evening, and thanks for having me tonight.
Now, I'd like to start with Barrister Deji Ajare. What are the implications of the Supreme Court reserving judgment on Atiku's appeal against President Bola Tinubu, particularly in the context of Nigerian politics? What does he mean to reserve judgment?
Well, yes, of course, there's quite a lot of tension, especially among the core political actors and actors in the election petition. The implication of reserving judgment essentially is simply that the Supreme Court has heard the argument of parties and it is going to go back. The panelists will go back and consider the submissions that have been made by the parties and then communicate a date to the lawyers for the judgment to be delivered. And I think essentially, well, all figures will be crossed at this point. We cannot preempt the Supreme Court. We cannot say what the Supreme Court's decision would be, and it would be improper and unprofessional for any of us here to sit down and predict really. But ultimately, I think what one is expecting is a very detailed and incisive judgment by the court, whichever way it goes. We expect the court to be able to, back up whatever decision it takes with solid arguments as after the consideration of the arguments of both parties.
Now, stay with you, Deji. Is there a time frame to this?
Oh yes, there's a time frame. There's a time limited for the Supreme Court for the appeal to end, and so one expects that the Supreme Court, I think it's about it's a total of 60 days from when the petition is filed, and so the Supreme Court has all of that time. It's impressive, really, the speed with which the Supreme Court heard this petition, the appeal, and one expects that the judgment will also come speedily too, like that. And one actually will also hope that this kind of dexterity will be extended to all other matters in the judicial system, other than election petitions, really. Because the experience is totally different from what you have in other matters.
Very true. Now, Deji, the President Bola Ahmed Tinubu, INEC declared him winner of the elections, and a few parties are not happy with that. They then decided to go to court What were the specific legal arguments and evidence put forth by these parties that went to court? They still have their cases in the Supreme Court. Elijah Atiku Abubakar, Peter Obi, and the Allied People's Movement in their appeals against the presidential election results. How do they differ from one another? And does the court treat them as the same or on their individual merits?
Yes, of course. The cases presented by all of the parties are different. First, in the sense that at least as between the Labour Party candidates and between the PDP candidates, they are both claiming to have actually won the election and not President Bola Ahmed Tinubu. And so quite naturally, their claims are different because Mr. A of the PDP is saying I won and Mr. B of the LP is saying he won, as opposed to Mr. C of the APC. Now, it is quite difficult, of course, to merge the arguments there. But on the other hand, I think the fulcrum, the pedestal upon which they placed their cases to are similar in the sense that both parties are also arguing about non-compliance and irregularities in the electoral process and procedure. But other than that, you also find that there are differences in the sense that the Labour Party legal team seems to place a lot of emphasis on the alleged conviction of Mr. President Bola Ahmed Tinubu in the US, his forfeiture of $460,000, and of course, they also claimed that there were irregularities too in his biodata. So, but beyond that, it would appear like the grounds of all of the parties essentially is that there was non-compliance, but by and large you have these minor differences here, because that of the PDP, for instance, seems to focus on the academic records of President Bola Ahmed Tinubu, while that of the Labour Party seems to focus on the 25% in the FCT, not obtaining 25% in the FCT, as well as the alleged conviction.
Now, staying with you, Deji, still on this court case, in light of the previous judgment by the Presidential Election Petition Tribunal, which upheld President Tinubu's victory, what challenges, you just mentioned some of them, what challenges do Atiku and Peter Obi face in convincing the apex court, the Supreme Court, to nullify the election results? There's some time have passed between the PPT judgment and the Supreme Court's pronouncement of the judgment. And I know that Elijah Atiku went to America and his lawyers got some documents. Could you, for the sake of our viewers, help us understand the process? Is the Labour Party going to present fresh evidence, or they're standing on their initial grounds in the Presidential Election Petition Tribunal? And Elijah Atiku Abubakar's new evidence, would it be admitted into court? And what would it take for them to make a compelling case for the Supreme Court to dismiss the judgment of the Presidential Election Petition Tribunal? How much of a task did they have to?
Bigger, really. I think it is hard, really, for anybody to sit down and preempt the Supreme Court here. It would be improper, really. However, you must understand that as a general rule, fresh evidence is not generally allowed on appeal, but there are exceptional circumstances under which this may be permitted. I think ultimately it will be for the Supreme Court to decide whether this is one of those situations where it would permit fresh evidence.
And at what point do they decide if they will be permitted, as we are following this case with rapt attention?
No, if the Supreme Court, of course, decides that it is going to allow fresh evidence, what it means is that it will only rule on the application of the PDP seeking to tender fresh evidence.
Okay.
And then, of course, it might just go ahead and sit as the trial court, take the evidence, and then eventually reach a decision. But on the other hand, it is not also impossible, but I think that's about the best the Supreme Court can do, because the Supreme Court cannot return the matter back to the lower court for it to be tried, given the fact that there are constitutional restraints, there are constitutional limits to the number of days that the Presidential Election Petition Tribunal can sit. And of course, in fact, the tribunal stands disbanded as it is right now.
Thank you very much, Barrister Deji Ajare. I'd like to bring in our second panelist and guest into the conversation, Barrister Obono Obla, former chairman, defunct Special Presidential Investigation Panel. Barrister Obono Obla, thanks for joining us. Could you kindly delve into the intricacies of the legal process in Nigeria when it comes to challenging presidential elections? What are the precedents and what are the typical steps involved, and how do they relate to this specific appeals?
Yes, it is very, very difficult to overturn a presidential election in Nigeria. The country is huge, made up of 774 local government areas, over 176,000 polling units, over 8,000 electoral wards. So it's an Herculean task to gather evidence that can, you can present before the courts for the courts to use to overturn a presidential election. And the precedents are there from 1979, when we started approaching the presidential constitution. You remember that Chief Obafemi Awolowo challenged Alhaji Shehu Shagari of the MPN. And the challenge was that then Nigeria was made up of 19 states. And Shehu Shagari won in 12 states. Obafemi Awolowo won in 6 states. But Shehu Shagari did not win the required 25% in 2/3 of 19 states. And the matter went to the Supreme Court, and the Supreme Court said, even though Shehu Shagari do not score 25% in Kano State, to make it 13 states. Despite that, the Supreme Court heard that winning in 12 states and having 19% in Kano was sufficient for Alhaji Shehu Shagari to be declared the president. Then we went into military rule, and in 1999, when we returned to democratic civil rule, you know that there was also a challenge to the election of Chief Olusegun Obasanjo. Yes, by the candidate of APP then, the defunct APP, Olufalaye. And the same thing happened. The petition was thrown out. In 2003, there was also a challenge by the former president, Muhammadu Buhari, also Chief Ojukwu, challenged the presidential election of 2003, and they lost. 2007, Atiku Abubakar challenged the election of President Yar'Adua. Buhari challenged, and they both lost. 2011, I was in the CPC legal team, and the elections was not challenged by Muhammadu Buhari, but his political party, the defunct Congress of Progressive Change, challenged the election against President Goodluck Jonathan, and we lost. Then in 2015, there was no challenge. In 2019, there was a challenge, and the people who challenged the election, Atiku Abubakar, lost. So it's very difficult to overturn an election, because the election proceedings are very technical. They are not like ordinary civil proceedings. So many things are not allowed, like the instant case, trying to bring in fresh evidence more than 6 months after the petition was filed. I don't see the Supreme Court overturning the judgments of the Presidential Election Petition Tribunal. Based on precedents, I've read the judgment from page 1 to the last page. They were very thorough, and they examined all the issues, applied the law, validated the evidence very well. So the challenge, now we are in the Supreme Court. The Supreme Court is sitting in its appellate jurisdiction. It is not sitting as a court of first instance. And the Supreme Court is always very reluctant to overturn findings of facts. The findings of facts have been made, several findings of facts, as regards the qualification of President Bola Ahmed Tinubu. It was resolved in his favor, and so many other issues. So I do not see the Supreme Court disturbing those findings of facts. So I will predict that the Supreme Court will not allow the fresh evidence, because this is an election. It's not an ordinary civil proceedings. If you allow the fresh elections, you would have succeeded in denying the respondents, as President Bola Ahmed Tinubu, his fundamental right to fair hearing, because he will not have the opportunity of confronting the evidence they have put forward. So I don't see the Supreme Court doing that. You know that the Supreme Court has almost, today is 23rd, they have about maybe 12 days or so, or 14 days for the petition for the case to lapse.
Yes.
Because the law says the judgment was delivered 60 days from when the lower court, that is the Presidential Election Tribunal, delivered its judgment on the 6th of September. So by 7th of November 2023, that case will lapse. So I don't see the Supreme Court granting the application for fresh evidence and then setting that date for for the case to be heard and judgment given. So I don't see that. This is an election matter. You cannot call fresh evidence at the stage that Atiku Abubakar is trying to bring in.
Now, staying with you, Barrister Obono-Obla, we now live in what people call the digital age. Social media is very powerful. We did see social media posts of all eyes on the judiciary, billboards, telling the judiciary and the Supreme Court that please do what is right for Nigerians, putting the search beam on them that, look, we're watching you guys. Now, putting that aside and using it as a background, how does the public sentiment and political climate in Nigeria factor into this legal proceedings and their potential outcomes? Is it something that the justices consider, the mood of the nation? Yes, and are there any notable public opinions? I'm not done with my questions, sir. Are there any notable public opinions or reactions that may influence the Supreme Court's judgment?
Well, I can tell you that the type of jurisprudence we practice in Nigeria, which is the common law tradition, the common law tradition is very conservative. It's not like the American reality school of jurisprudence, where people are very dramatic. There's so much drama in court, and all those things sway the judges. The kind of jurisprudence we have, the law says the judges should not be swayed by emotion. The judges should not be swayed by sentiments. The judges should be swayed by hard law and evidence that has been adduced before the court. So all the drama in social media, all the noise in beer parlors and in the newspapers, will not sway the judges. And you remember, the Chief Justice of Nigeria had warned that judges should not be sentimental. They should not be emotional when they are dealing with election petition cases. So I don't see that as influencing the Supreme Court to leave the law and pander to emotion and sentiment. The Supreme Court will not do that. Also remember that the Supreme Court is a court of policy. So the Supreme Court is sitting as a court of law and as a court of policy. In the public policy is that this is an election that was conducted in 36 states and the federal capital of Nigeria. A lot of money has been wasted. And the country is a country that is, the history of the country all those factors of what has happened, what we have seen in this country since independence, all those things are way on the minds of the justices not to disturb an election that would destabilize the country, because there is no evidence that this election was rigged, and which the tribunal has look, this election was never rigged. This election was well conducted, and you don't expect that in an election of this nature you will not see mistakes here and there. But are those mistakes, are they substantial to affect the outcome of the election? That is the question. And I don't think everything the petitioners have alleged is substantial enough to disturb the outcome of the election. The election is a reflection of what the people of Nigeria wanted.
Thank you very much, Barrister Bola Obla. Now, Barrister Deji Ajare, with the withdrawal of the APM's appeal and the argument that the party was asking the Supreme Court to redo what we have done, how might this decision influence the overall legal landscape and perception of these cases?
Been withdrawn, and I think having been withdrawn, it is dead, and it is well, I wouldn't say unfortunate. I was actually looking forward to the outcome of that that case, because the arguments I thought had weight, especially considering the interpretation of Section 142 of the Constitution. It would have been quite enlightening to see how the Supreme Court will tackle.
What were they? Just
issue.
Let's track back a bit for those that have not been following this case. What was the APM's prayers to the court? Hello, Barrister Ajare. What was the reason why the APM wanted the results of the presidential elections overturned? Hello, Barrister Ajare. Okay, I think we lost connections with him. I'll just bring in Barrister Bola Obla back into the conversation. As we begin to wrap up this conversation, so many people have said, our courts are getting too busy. It's INEC's responsibility to conduct and announce results of elections, and we're seeing a lot of litigation. Now, in your analysis, Barrister Bola Obla, what are the possible long-term consequences of the Supreme Court's eventual decision on Nigeria's politics, and how might it shape the political landscape in the country moving forward? And also, what do we need to do as a nation, as a people, as not to, change, to move responsibility of conducting and announcing results from INEC to the courts? How do we reduce the amount of post-election litigations we see in our country?
Currently, the law and the precedents that have been laid down several years ago, one of them is that election as conducted by the Electoral Commission, the result is announced by the Electoral Commission is presumed to be correct until the contrary is proved. Also, the burden is on the petitioner to prove that that election was not properly conducted or was not conducted in compliance with the provisions of the Electoral Act and the Constitution. So if we are going to have reforms, the reforms ought to be carried out by the National Assembly. So nobody should expect judges to reform the law. Judges will only declare the law as it is provided by the lawmaker. The lawmaker is the National Assembly of Nigeria. So all those lapses we have seen, like for instance, the electoral transmission of results, which is not in the Electoral Act, and the opposition, the petitioners are insisting that, results ought to have been transmitted electronically. The National Assembly can, based on the pronouncement of the Supreme Court, they can, amend the law to make provisions for electoral transmission of results. if that will help, our democracy to be deepened, our democracy to flourish, and to also reduce the litigation, the post-election litigation, which I think it has reduced drastically. Because I was a counsel in 2007. I also was a counsel in 2011 and in 2014 or 15. I can say that the amount of litigation has reduced drastically.
So we're making progress.
Then I say that INEC has been conducting as lines its lesson from all the judgments, all the pronouncements of election tribunals and the Supreme Court. I think we'll get there. We'll get there. Our democracy is still young. We are barely 25 years. And if America, with over 300 years of the practice of constitutional democracy, can, you saw what happened when Biden won and Trump came out to say that the elections were not properly conducted. So if that kind of a scenario can happen in America, that is presumed to be the bastion of democracy, how much less Nigeria, with just less than 25 years of the practice of constitutional democracy?
Thank you so much for your insights and your contribution, Barrister Okoye Ogbonna, and also Barrister Deji Ajare. It was a pleasure having you both join me on the program tonight. Thank you.
Thank you. It's a pleasure.